You're listening to the Today's Wills and Probate podcast, one of the leading sources of information for the wills and probate sector. Don't forget to subscribe and sign up to our free newsletter at todayswillsandprobate.co.uk and follow us on LinkedIn and Twitter.
Hello, welcome along to the latest Today's Wills and Probates podcast. Today we're chatting about the challenge of wearing two hats, the Professional Standards Board, regulation, and the response to the Competition and Markets Authority draft guidance that has been produced. We've not yet had that signed off, although we've seen plenty of organisations respond to it. My guest today is Antony Brinkman. Antony is the CEO of the Willwriting Partnership and handily, for the purposes of the podcast, the chair of the Professional Standards Board. So well placed to speak on both counts. Thanks very much indeed for joining, Antony.
Thanks for inviting me.
Bit of a long-winded introduction, so apologies. But in the first instance, perhaps you might give the listeners a flavour of who you are, what you do. You, as I say, you wear a number of different hats. That will no doubt be a lot of fun and also present a number of challenges as well.
Yeah, I've been in the estate planning industry since the late 90s. Of late, I've taken on a number of additional hats, as you say. The Professional Standards Board is a part of the Society of Will Writers. It's an independent board which has a purpose of increasing and helping to increase the standards and better the standards within the society membership. Perhaps in the future there'll be a kind of wider scope that we have, and it'd be nice to think that we can at some point be instrumental in galvanizing some of the collaboration in the industry, which would be beneficial to all of us. All the different membership bodies that are out there are all kind of striving in the same direction, and I think more collaboration at some point will be needed. It would definitely beneficial overall for the whole profession. So that would be good to think we can be instrumental in that. But yeah, at the moment, the Professional Standards Board is a part of the Society of Will Writers, and we perform a number of functions for the society on behalf of the members. So that's one of the hats that I wear, chairman of that. I also am a tutor at the College of Will Writing. I've been a tutor there for about the last 6 years. There's 3 different courses that I tutor at the college. And I also have a podcast that I host, the Estate Planners podcast. So yeah, a number of different hats, and you're right, there's some challenges to accommodating all of those different things, but I do like a challenge.
Tell us about your role on the PSB then. You describe yourself as the chairman, and you've given a very brief introduction to what the role of the PSB is, but how does that manifest? What's your kind of role?
Well, there's the chairing of the meetings, of course, which can get a bit lively, so that's an interesting task, but also the projects that we work on. We've got really 2 arms, I suppose, to what we do. One is the projects that we undertake, which have a definite end point. There'll be a finite end to a project. So, for example, reviewing the code of conduct. We did a big review of the Society of Will Writers Code of Conduct, brought it much more into the 21st century, made it a lot more relevant, got rid of some of the things that weren't needed anymore, enhanced some of the elements that can definitely afford more protection for the end users of the members' services. But that had a finite end. So that was then a completed project, box ticked, move on to the next one. And we have subgroups within the board that then work on those projects. We also have ongoing functions as well, though. So, for example, there is the complaints function. So if a client makes a complaint to a member of the Society of Will Writers, then the society will deal with that to a certain point. But if it gets elevated beyond that and it can't be resolved, it gets passed to the PSB, and we'll take it on and find a resolution, hopefully to the satisfaction of both parties. But that's pretty rare. It's usually one that's kind of happy and the other's unhappy, but hey. So that's an ongoing function. There are a few of those as well. So my job, I suppose, as the chairman is to steer those projects, make sure that they are getting completed. At the end of the day, it's to enhance the value of membership of the society. We're there for the members, and we're there for the clients that they then ultimately service.
And it's important distinction to make that it's a separate function from the society, isn't it?
Yeah, it's important that we stand independent of the society, because we're not always going to see exactly eye to eye, and there's occasions where we have to really help to steer them in a certain direction. Obviously, we're there to service members. We're there to all of us to help and enhance the skills and the quality of the members' competence and abilities, their product knowledge, their technical knowledge, and so on. We're on the same team, but we might have a slightly different viewpoint, of course, because we are members as well. That we are members of the society. So we have that practical, on the ground viewpoint, as well as being able to stand back a little bit and take an objective look at, let's say, a project such as the audits, the annual audits which get submitted to the society, which all membership bodies, the IPW and BEST, all have audits that are sent in by the members. And those have questions on them. Some of them are relevant. Some of them it's a bit of an admin exercise. So when we reviewed the audits, we're trying to strip out things that are just not useful anymore, and perhaps add in additional questions that are useful, that is good information for the society to be able to take on board. So we'll have a different viewpoint sometimes from the society itself, and it's good. It's good. That's a healthy relationship that we've got there.
And you've been very modest about the fact that you're also the CEO of the Willwriting Partnership, which is one of the largest will writing providers in the UK. How does that complement the role on the PSB, and what do you do at the Willwriting Partnership?
So that's, I suppose, similarly, I'm steering the company there in certain directions. There are ways that we want to continually enhance the quality of the services that we're providing to our clients. The wills, the LPAs that we produce, they're not going to get put to the test until years down the line. So we've got to know that the quality is there. So the training of our consultants, the development of courses, and the different tools that we use to bring that service to the client, those are the things that I'm mainly working on with the company, and the growth of the company, the stability of the company, that kind of thing. I try to keep that very distinctly separate from the professional standards board and the other hats that I wear. I don't want it to overlap too much. I don't want to muddy the waters in any way. So I don't kind of shout about each of these different hats. I don't cross over these hats, if you like. Yeah, that's probably a better way of putting it.
I want to come on to the response to the Competition Markets Authority guidance in a second, but tell us about a recent project that you might have done on the PSB that's had an impact on the membership.
Well, one of the most relevant, I suppose, recently was the expansion of the Code of Conduct, which was an important review to do. That is, at the end of the day, what all members sign up to. They all agree when they come on board as members of the society, they agree to adhere to the Code of Practice. So that's what binds us all together. That's what holds the membership in place, really. So it was an important review to do. But one area that we really expanded upon was the oversight and governance of the members. And previously there was really only one response to a complaint, which was to get rid of a member. And that's a bit of a blunt stick. So we expanded that and incorporated a number of different ways that we can correct and help members who are perhaps going off in the wrong direction or have had a complaint against them, which indicates that they have something wrong within their company. They might need retraining, they might need to attend a few courses at their own cost. They might, there are other things that can be done to correct somebody who is doing something wrong. So we expanded the code to incorporate a clearer picture of what is right, what is wrong within a member's practices, and the powers that we've got to be able to help and correct them. The outcome of that, because that was a few months ago that we completed that, and that new code was released, and I've had feedback from a number of members who have paid attention to that, and they've taken on board those enhancements, those changes, some of whom have they've responded well, they've responded positively to those changes, and they've made changes within their own company, which is of course beneficial then ultimately to their clients, and that's good for us all. Everyone who's in this industry, if we are collectively delivering a better service than we were last month, last year, then that's good. That builds public confidence, and that's got to be good for all of us.
There's a risk we're going to stray into a topic I still want to cover a bit later on, which is regulation. But let me ask you, Do you feel as though we're moving in the right direction in terms of the quality of will writing?
Yes, I suppose we are moving in the right direction is the clean answer to that question. There are always going to be things that we can do better. There's always going to be ways that we can improve as a profession, collectively, moving with the times, making better use of technology. That kind of thing is, we've got to be doing a better job and seem to be doing a better job. And we're perhaps not the best at things like making use of social media and that kind of thing. I mean, I'm the worst at that myself. I've got, I'm really poor when it comes to social media. But as a profession, the ability for us to show the good works that we're doing is important, I think. And as far as regulation, you touched on that point there. I think we're probably moving in that direction. I think at some point, almost certainly, there will be regulation of some form. You look at the industries that have, historically, we've had financial services that have become regulated, mortgages that have become regulated. Of late, of course, we've had funeral plans that have now fallen under regulation, and that is kind of the direction, isn't it? So that's not a bad thing. Heavy regulation would be a bad thing because that would limit choice for a fundamentally important, vital service that we provide. And I think limiting choice would be a bad thing, of course, but the quality of the service is almost inevitable that at some point there'll be some form of regulation, in my opinion.
Perhaps with my tongue in my cheek then, should the role of the PSB be to prepare for regulation or to try and stave it off?
I would suggest it's the former. We if we are going to be instrumental in those future collaborations that I mentioned before, then it's going to be in the direction of some form of regulation. And yes, at the moment, we're getting our own house in order as far as the Society of Will Writers is concerned, but we've already started to make steps towards reaching out to other membership organisations, and I think that's going to be vital. It's of benefit to all of us to have that collective input into the way that this industry is going and what the outcome of anything such as the CMA consultation, that's an indicator, isn't it, that there is attention on us as a profession. Let's use that impetus to make causative changes ourselves to which direction this is going. And yes, I think it's more towards the regulation than staving off regulation.
Historically, there hasn't been a huge amount of collaboration between the membership bodies. You've talked already a couple of times about collaboration, that you've already started to reach out as a group. How is that developing? What's the kind of plan there, or is it still very early days? What can you tell us about that?
Certainly, I see more collaboration now. I see more communication now. It's where it all starts, isn't it? People communicating with each other. There have been a couple of meetings where the relevant or the bigger industry bodies have sat down together and they've participated in various things together, which is vital. It's important, and there's more of that now than there has been historically. So I do observe that, and if it's going in that direction, then great. More of the same in the future. It's got to be a good thing.
Let's move on to very specifically talk about the Competition and Markets Authority draft guidance on will writing. Very clear from that publication that it was never the Competition and Markets Authority position to say that it should be regulated in some way. And indeed, the Legal Services Board have so far sort of said, it's not on the agenda in the short term. But the guidance outlines protections that should be there for consumers that, in its opinion, aren't. Let's go back to the reaction to the launch of the investigation back in 2023.
So yeah, the first reaction, I suppose not one of surprise, because it's been a while. I think it was 2013 when there was last any kind of major push or attention on what should be done regulation wise or licensing wise or anything like that. I think it's a good 10 years ago now. So it wasn't a surprise that something has come up. Perhaps the nature of it was a little bit of a surprise though. And the direction of it from the CMA, should it perhaps have come from somewhere else? Don't know, but it's there. We put together a response as a PSB, and we put together a response as the Society of Will Writers, of course, to that, and largely welcomed the fact that there was some interest in the unregulated sector. We're aware, of course, that there are practitioners in any industry, I suppose, that are not helping people as they should be. And at the end of the day, this is really centered around existing consumer law, which exists. It's there. It's not something that's new. Therefore, it's pulling our attention as a profession in that direction, and giving us more clarity of how we as a profession should be applying those existing consumer laws. Again, the purpose of the PSB is the increase of standards within the profession. So anything that nudges us in that direction has got to be a good thing. We're always going to be welcoming things that push in that direction. The flavour of this is definitely in that direction for sure.
I don't know whether you'll appreciate this question, Antony, but should the PSB or the SWW have picked this up before the CMA?
Good question. I suppose the nature of what we do as a PSB is this. It is the increasing of standards. It is looking at, well, what is it that members are doing that they shouldn't be doing, or that they shouldn't be doing that they are doing, and correcting those. As a membership body, we have some control over that, which is great, and we've got the ability therefore to influence what members do and how they operate. But of course, an external body, the CMA, don't necessarily have that. They've not got that intimate connection with those practitioners. That's very much at arm's length. Therefore, this type of consultation is the only way that they can make motions in that direction. Maybe we should. Maybe the society should have been ahead of the game, I suppose. But the fact that the PSB actually does exist, we were there and stood ready to respond and to take this on board and promote it.
The recent Today's Wills and Probate Industry Summit identified exactly what you said at the start of that point, which is that there are some excellent will writers out there. There are some very poor will writers out there, in exactly the same way that there are some excellent solicitors out there and some very poor solicitors out there. So this is not a conversation about, which is better regulated or unregulated by any stretch of the imagination. And I appreciate your candor on that as well. Let's think about the guidance itself then. Thoughts on whether it goes far enough, any points that you particularly agreed with or disagreed with either hat on, either as the Willwriting Partnership or as PSB?
I'll wear the PSB hat, I think, firstly. So it could have gone further. If we look at the purpose of this, what's the whole point to this CMA investigation? Why has it come about? What are they trying to solve? What problem are they trying to solve? We perhaps will never know the answer to that question, but there were some concerns. It mentions in the initial summary of this investigation that they had concerns about certain areas, and they gave a few examples. Consumers being misled by advertising, which offers an extremely low initial fee for advice but doesn't indicate that final costs can increase significantly. Use of unfair contract terms, such as exclusions of liability. So there are a few specific areas that they highlighted as being matters of concern. But what we don't know, of course, is, well, which companies were causing that concern? How many concerns were there? What was the extent of the mis-selling or the pressure selling? We don't know the answers to those questions. This guidance is going to be read by the people who are engaged with this podcast, who are listening to this podcast, who are reading Today's Wills and Probate, who are members of the Society of Will Writers or the Institute of Paralegals, the Institute of Professional Will Writers. Those are the people that are engaged in this industry anyway. Those are the ones that are going to be reading this and absorbing it and making use of this guidance and incorporating it into their business practices and so on. But that doesn't solve the problem, I don't think, that the CMA are trying to solve, which is the people who are not engaged, the people that are not doing a good job. So no, it doesn't go far enough. I think there's a missed opportunity here to minimally enforce any practitioner, any person who is in this unregulated sector. Being a member of one of those existing membership bodies would have been a much stronger step in the right direction, that's for sure, because we all have those codes of conduct, we all have those abilities to correct members when they're doing something wrong. That was potentially a missed opportunity, I think.
I know you've got a couple of points that you agree and disagree with, if you wanted to share those.
So the guidance gives directions on things like, for example, pricing and transparency. And of course, that's a great thing, you know, the clarity of pricing and saying what the price is and being clear and honest and transparent about one's pricing is a good thing. We've all come across those companies that are advertising their services at ridiculously discounted prices, and you just know that that's not going to be what the consumer pays in the end, and that therefore is misleading. But there are a few other areas where they could have, I think, touched on or given examples to clarify pricing, one of them being VAT. You know, we are primarily, almost exclusively, a business to consumer service. Of course, you're going to get business clients who VAT is relevant to, but the vast majority of consumers are not used to calculating VAT in their head. So advertising a price as, you know, £100 plus VAT, £200 plus VAT, if a consumer is not used to thinking with that, they don't immediately know that that's 120 quid or 240 quid. So that would have been a good example to give when it comes to being clear on pricing. There are also some areas where they could have given more guidance, I think, or a couple of points that I disagreed with. There was one mention of the use of disclaimers, for example, and the fact that disclaimers were kind of shown to be a bad thing, you know, that they were part of pressure selling, whereas disclaimers have their place, I think, particularly in an industry where we are giving advice today on a situation which might not come to fruition for many years, and of course where the person that we are giving advice to is no longer in a position to state what their viewpoint was. So in other words, if we advise today, Mr. and Mrs. Smith, I advise that you do A, and they choose to do B, that could have bad consequences in the future. And to show that we've had that conversation, they've made that decision, and we've outlined why we've given advice to go down route A, and they've signed to say, we understand that, but actually we're going to take route B, that's some protection in place for us in the future. But of course, the flavour of what they were trying to say there is correct, that it shouldn't be used to missell something or to pressure sell somebody into taking a service that they don't need. But that's the misuse of the tool. It's the person that's using the tool that needs correcting, not the tool itself. I think there's a few things which need some correction or clarification in the guidance, but broadly, I've got to say, the guidance is good. It's positive, it's moving in the right direction, and I think it is going to help a lot of will writers, a lot of solicitors to see what good practice looks like. And they're given some good examples, they're given some do's and don'ts, checklists. So that's got to be that's going to be helpful to people for sure.
I wholeheartedly accept, understand, and agree with the point you make about those who are engaged with this process are the ones that are the good eggs, and those who aren't engaged with this process are simply the ones that will largely ignore it. And of course, the real meat in this is the way in which the CMA subsequently may or may not crack down on it, which is yet to be seen. What takeaways have you implemented in the Willwriting Partnership that you may or may not have been doing beforehand?
We've implemented a couple of changes, albeit relatively minor, which are to do with our instruction forms. So the instruction forms at the end of the day is the most important tool of this trade, as far as I can see, apart from a pen maybe or a computer. The instruction forms are the things that guide us through the client appointment. You know, if they're set out logically and systematically, then that helps structure the appointment itself. So we've made a few changes to the instruction forms that we use, just to give clarity and clarification to consultants so that they can provide more tailored advice to the clients. And, that's been as a result of some of the points that are brought up in this guidance. We've not made any changes that are fundamental. There's nothing that we're doing as a company that we kind of thought, oh my God, we must stop this, or we have to change that. There was nothing major. These are sort of tweaks on the general business model. Of course, we don't have the end product yet from this CMA investigation, so that may enforce changes, but there's nothing kind of major in the Willwriting Partnership that we've had to implement to accommodate this. Just little tweaks and changes which improve things.
So as we come to the conclusion of the discussion, Antony, I wondered if you might share some thoughts on what the opportunities for the profession is over the next 1 to 5 years.
There is one observation that I've made over the years from these various different hats that I wear, whether it's the Willwriting Partnership itself, Professional Standards Board, the podcast, and some of the feedback that I get from the podcast, or being a tutor particularly, I suppose. And that's to do with balance within our CPD, within our continued professional development, between skills and knowledge. And this applies not just in estate planning and will writing and the legal sector. I think this applies probably in accountancy and financial services. I see this kind of across the professional services industries. There's an imbalance between skills and development of skills and development of product knowledge and technical knowledge. We're very heavily weighted towards technical knowledge. When you look at, if you go to a conference, typically the vast majority, if not all the speakers, will be about technical subjects rather than skills-based subjects. And don't misunderstand this, I'm a very heavy advocate of the fact that we should have as good a technical knowledge as we possibly can. That's fundamentally why clients pay us. So, yes, we should be absolutely as up to date as possible, as knowledgeable as possible, yes. However, we should also have some attention on developing skills and developing the practical know-how and the practical abilities that we need to deal with the client. Because you could be the most knowledgeable, well-qualified, amazing technical skills as far as the services that we provide. You can have an encyclopedic knowledge of wills and how to craft a will, but unless you can communicate well as a skill, and unless you have those client interaction skills, unless you're able to educate, there's an educational element to what we do. Clients don't necessarily know what a trust is or how it works. They don't know what a lasting power of attorney is or what it means to be an attorney. So we need to be able to educate people and communicate with people, and those skills need developing. And I don't observe that enough time is spent by practitioners on developing those skills, whether that's collaboration within those membership bodies. We all go to meetings, and you mentioned the summit before. We all know other people within the industry. So, you can sit down with a colleague and go through an instruction taking meeting with a colleague and get critiqued and improve the skills themselves. I think that's a distinctly missing area in terms of our industry. And I just kind of want to wave the flag somewhat for the development of skills as well as technical knowledge. I think that's whenever I've done that, I've seen some pretty steep increases in the amount of clients I've been able to help or the feedback that I've got. And I want to wave that flag. And I'll jump off my soapbox now, but I think it's a good thing to promote is the development of skills as well.
That's certainly something that we see across the publications that we have as an organisation. So Today's Media publishes a news publication for family lawyers, for wills and probate lawyers, and for conveyancing lawyers. And in the nicest possible way, you are all very, very different creatures. And you have to look at it in the context of what you do all day. You deal with death. You deal with very, very difficult conversations every day that we know people don't want to have. Otherwise, the number of wills we have would be much higher as a percentage. Family lawyers are the same. They deal with very difficult conversations, whether it's a divorce or whether it's a child issue. They're dealing with really difficult conversations. Communication is a massive, massive part of the role of legal services. So at the risk of both of us being on our soapbox, I wholeheartedly agree with that one as well, Antony. I think that's a really important area to develop as a skill.
Well, I'm glad to hear that. We can wave that flag together.
We're out of time. It's been fantastic to have you on the podcast, Antony. Thank you so much. You've brought a number of hats along, which has been helpful. So you can pop those back on the rack as you exit. But thank you so much for joining and for sharing your insight.
Thank you for inviting me. It's been a pleasure.
The Today's Wills and Probate podcast is available on your preferred podcast provider. It's also available on todayswillsandprobate.co.uk. My thanks to Antony. Thank you as ever for listening, and we'll see you again soon.
You're listening to the Today's Wills and Probate podcast, one of the leading sources of information for the wills and probate sector. Don't forget to subscribe and sign up to our free newsletter at todayswillsandprobate.co.uk and follow us on LinkedIn and Twitter.